Coming up next on the Jeff Crilley Show, we'll be talking to a veteran attorney with more than 40 years of experience under his belt about things that all small to medium-sized business owners need to know. That's next.
Many are predicting that the worst is yet to come, which is unfortunate, said one person here. Until now, they've enjoyed the reputation of being the nation's icebox.
Watched a burglar in his home this morning by webcam.
As a journalist of over 25 years, stories are what make my world turn.
Reporting live from the Dallas newsroom tonight, Jeff Crilley, Fox 4 News.
But in 2008, I took the jump from my familiar life and started a PR firm from my home.
We're talking about anyone with a camcorder like the one I'm using becomes a television network.
We started slowly growing the company, and we now have over 100 clients, and we've branched into the world of live digital broadcasting. I now own 8 different TV studios and have a huge team, and the stories that I now get to share are sometimes the most important of my life. Life has a funny way of coming around full circle. This is the Jeff Crilley Show.
Well, when I was a TV reporter, I never gave much thought to what a small business owner needs to know legally. I was an employee after all. Now I own a small company, and I'm very aware that there are things you can do and can't do, and things that you can do that can get you sued. To talk about that today, Richard Armstrong. He's a veteran attorney here in Dallas. Been 40 years. You look like a young man. I don't know how you pulled that off.
You lie very well, but thank you. I'm happy to be here.
All right. So before we get into things that business owners need to know, tell us about your career path. Have you always wanted to be an attorney?
No, actually, early on, I was kind of in music in college. I did a lot there. I was a business major as well, and briefly was on a journalism staff at a fairly young junior college before I transferred to a 4-year university. During that time, I became exposed to a lot of things that were legal in nature, and I saw it. I decided to make a pivot and went into it and enjoyed it very much and have been in it ever since.
And you've done a little bit of everything, criminal, civil, jury trials.
Yeah, early on, I had the advantage many attorneys don't have. I went with a big firm early and then left and sampled a lot of things a la carte. And in doing that, I was able to try some criminal cases, some civil cases, business cases, fraud cases, you name it, I've done it.
Wow. Well, I worked at Fox 4 for many years alongside Clarice Tinsley, and you were sharing with me before we went on the air that you actually helped Clarice win a Peabody Award. Tell everybody about that.
Well, I don't know if I helped her win it. She did that herself. But I will say this. We had a case that I, as a young attorney, had no idea was coming. And it was a case that essentially succeeded in changing the entire 911 protocol when people call in with an emergency call. Gentleman called in. His stepmother was in the process of having a heart attack. He gets on the phone with the nurse who at the time, nurses were taking those calls. And basically she argued with him for a critical 7-minute period. And they got back on the phone once after having hung up, did it again. The same thing happened with her supervisor. Finally, that person died of a heart attack. This went first national, then international in a matter of days. I was being interviewed by Brian Gumbel on national news. Things were happening. But the important part for me, because the case settled relatively low for legal reasons I won't go into, but the important part for me was it changed the protocol on the 911 system forever.
Wow.
So that now they send an ambulance first, and they then ask the questions along the way and call back the ambulance if it's not needed. It was very gratifying to see that change happen.
Absolutely. Well, congratulations on that. And let's talk a little bit about COVID-19 and small businesses.
Sure.
What are some things, in the early days of the pandemic, I remember there was a lot of talk about, hey, do I have to pay my rent if I can't use my office space? I mean, did you see a flurry of activity in your practice?
Yes, I had to deliver the difficult news to a lot of my clients who were under lease. That no, there's no way you can get out because this is commercial. This is not residential. Mm-hmm. Residential tenants and even mortgagees had lots of relief because the government was behind many of those loans. Not so with commercial. So I had to tell them, unless you have what's called a force majeure clause in your contract, and that force majeure clause covers things like pandemics and epidemics, you're probably pretty much stuck unless you can go make a plea to your landlord and just say, will you please back off? Fortunately, that worked with some of them.
Yes.
But most of the force majeure clauses in the contracts just didn't cover pandemics and epidemics at that time. Now they do. We're learning from experience.
Yes.
In Tornado Alley here, for example, you want to be sure there's a tornado clause in the force majeure part of the contract.
Did it allow some people to just walk away from agreements that they had signed or not? Really?
Probably not. In most cases that I'm familiar with, Jeff, they were able to use that as a bargaining lever to either put off their rent for a period of time or lessen it or stair-step it. So they brought it down. Then every month after that, it went up a little bit until the sheltering order was over and there was some relief.
Yes. Well, you have a robust social media channel. We found a wonderful video you put up on YouTube. Let's go ahead and roll that now.
You know, there's no such thing as a guarantee against a frivolous lawsuit. One of the prices of having a free access to the justice system is that somebody can file that kind of a suit in many cases. But we find that it's a very good deterrent to those types of suits when you have a written employment agreement, particularly because if you build into the employment agreement benefits that are attractive to an employee, whether it may be something like severance benefits, whether it may be something like vacation, whether it may be something, a bonus structure, maybe even a stock option plan. Those kinds of things tend to provide an incentive for an employee not to wrangle with you in court. Also, the very fact that you've reduced things to writing and taken the trouble and time to do that and not just generated something off a copier, it communicates something to the employee. It says to the employee, this man knows what he's doing. This executive has taken the experience, taken his experience and applied it with his attorney to generate a document that means something. And I'd better watch my P's and Q's before I just run off to the courthouse. The objective here is to prevent or deter the employee from running off to the Equal Employment Opportunity Commission or the Texas Commission on Human Rights or some other agency or the court if there's some other way to solve the problem. And you can also build that into the contract, dispute resolution procedures that help you solve the issue with the employee.
Yeah, I think we all like to think that we live in a handshake society or, your word is your bond, but you have to get it in writing, don't you?
You have to, and it's even more important in the digital age. The problem you have in the digital age is that everything is check a box and you're stuck with those terms. People don't realize sometimes you can actually negotiate those terms. You got to have a little bit of forcefulness and I'm willing to say, let me see the actual stuff and negotiate it. But you're right, it has to be in writing.
Okay, let's talk about business divorces because, a lot of people have partnerships and sometimes they're the majority owner, sometimes it's a 50-50 split. What's your advice for somebody going into business?
Begin with the end in mind. And because we're all excited when anything new is starting, we tend to say, I'll get around to that tomorrow. Nothing could be further from the truth. I've actually been in so-called business divorces that happened within 6 months of formation. Mm-hmm. So go to an attorney, somebody like me who does business law, and say, I would like an agreement that takes care of the possibility that my partner gets divorced, dies, leaves and tries to sell to another partner, or believe it or not, goes insane, loses his marbles. Any of those are triggering events.
Yes.
So these agreements should have three things. They should have a triggering event. They should have a method of valuing the business. And they should have a means for buying out or a mechanism for funding. And that's the three things that something we have called a buy-sell agreement covers for business people. So you have a path to run on in the event that things don't go the way you want.
So if two people come to you and they want to split the business 50-50, are you going to advise that one take 51% and one take 49%?
Usually I will, but that's not always possible. If you have a Mutt and Jeff situation or Larry, Moe, and Curly and they want to all have the same percentage, there are what we call deadlock breaking mechanisms that you can build in. One of the toughest ones that can happen is a push-pull clause, and that's where basically if a buyer offers to buy somebody out at a certain number, and the other person says no, I don't want to sell, then that other person has to be prepared to buy him at the same number. Wow. So it's kind of a drop-dead clause, and you better be ready for that. There's also something called a provisional director. You can appoint somebody who will break a tie. It has to be somebody that both parties agree is a fair person and doesn't have an axe to grind. Mm-hmm. And then there's some other procedures like mediation or arbitration that could be built in.
And if people go to your website, you also have a free ebook that you put out. Let's go ahead and put that on the screen. Tell us more about that.
What I tried to do with the ebook is to distill into 8 essential points the things that I see most come up that are bumps in the road for business people.
Sure.
You mentioned one, get it in writing. That's the first chapter. The last chapter is devoted to cyber liability, which is the most recent thing we've had. And there's things in between, employment agreements, various other types of things that a business owner should address and have top of mind when he sets up his business.
Well, you mentioned cyber. What are the pitfalls and perils of cybersecurity and getting hacked?
Well, first, let me start out by saying there's a popular misconception, Jeff, that there are no dangers to small business out there. Why would they want me? They can go after IBM. They can go after Raytheon, whoever. The problem with that is that there is, it may be off the radar to you, but people who do this kind of stuff are looking for it all the time. And because of that very fallacy, the average small, medium-sized business owner just says, I won't do anything about it. They're very exposed. So legal, now there's things you can do. Cyber insurance is one of them. But legally, what you need to do is be aware of the law. So that entails if you have a breach, do not, I repeat, try to cover it up. That's your first instinct is, I'll pretend it didn't happen and nobody will notice. No, sure. You've got 60 days under the state of Texas law statute, 60 days from the time you discover it to let everybody know that either was affected or reasonably could have been affected. If you don't, you're going to be paying a per day fine that is very steep and a $250,000 fine on top of that. But here's the worst part. If you don't do that and you're later sued for negligence by a client or prospective client that was affected, one of the first, Exhibit A in that trial is going to be what you didn't do to comply with the law. Mm-hmm. That then establishes what's called the standard of care. Once the jury hears about the standard of care being violated, the book is open on how much damage they can assess, and it can make that $250,000 seem like nothing.
Yes. We only have about a minute left. So for the small business owner who does not have a relationship with an attorney like you, would you advise them to go ahead and at least start to build a rapport with an attorney, even if they don't have a pressing legal need?
Exactly. And we have a model for that very thing, which we call fractional general counsel. It is a proactive representation model for small business. And the whole purpose of it is to get over this idea that you only go to an attorney when the flames are rising and the alligators are closing in. That's when it's most expensive to hire an attorney because they have to get familiar with you rapidly.
Yes.
So what you really want is somebody who knows about your business already and is representing you on an ongoing proactive basis. That's what we call general counsel. We provide those services. We have a lot of clients that appreciate that, and feel free to contact us at any time.
Outstanding. Ray, you've been a great guest. We'll have to have you back again soon. We're going to end with the website to get in touch. PlanoBusinessLawyers.com is the website. Richard Armstrong, thank you for coming on the show.
Thank you, Jeff. I appreciate it.
You bet. And that's it for now. We'll see you next time.